This is passage number 2. Duration 6 minutes. Speed 100 words per minute. Dictation starts now. The present appeal has been filed by the original claimants seeking enhancement of the compensation awarded by the Motor Accident Claims Tribunal in a judgment dated 10th April 2022. The deceased, who was 35 years of age at the time of the accident, was working as a supervisor in a private construction company. While he was returning home on his motorcycle, a speeding truck coming from the opposite direction hit him head on. Due to the impact of the collision, the deceased sustained grievous head injuries and succumbed to his wounds on the spot. The tribunal, after considering the evidence, awarded her a total compensation of 12 lakh rupees to the defendants. Para. The learned counsel for the appellants submitted that the tribunal committed a serious error in calculating the monthly income of the deceased. Although the salary certificate was produced and the employer was examined as a witness, the tribunal arbitrarily deducted a significant portion of the income under the head of personal expenses. Furthermore, it is contended that the tribunal failed to award any amount towards future prospects, which is mandatory as per the settled law laid down by the Constitution bench of the Honorable Supreme Court. The Council prayed for a just and fair compensation considering the rising cost of living. Para. On the other hand, the learned counsel representing the insurance company argued that the compensation awarded is already on the higher side. He pointed out that there was an element of contributory negligence on the part of the deceased, as he was not wearing a helmet at the time of the accident. The company maintains that the tribunal has rightly evaluated the oral and documentary evidence and there is no scope for further enhancement. It was further argued that the interest rate of 6% per annum awarded by the tribunal is reasonable and consistent with the prevailing bank rates. Para. We have scrutinized the record and the findings recorded by the learned tribunal. The first issue for our consideration is the determination of the monthly income. Upon perusing the testimony of the manager of the construction firm, it is clear that the deceased was a permanent employee with a fixed salary. Therefore, the tribunal was not justified in ignoring the actual salary of the deceased. We also find merit in the contention regarding future prospects for a person in a permanent job below the age of 40 years. An addition of 40% of the established income should be made towards future prospects. Para. Regarding the issue of contributory negligence, there is no conclusive evidence on record to prove that the absence of a helmet contributed to the death. In the absence of a post-mortem report specifically mentioning that the death could have been avoided with a helmet, a deduction for contributory negligence cannot be made mechanically. Therefore, we set aside the finding of the tribunal on this point. The claimants are also entitled to compensation under conventional heads, namely loss of estate, loss of consortium, and funeral expenses. Para. In view of the aforesaid reasons, the appeal is partly allowed. The monthly income is refixed at 25,000 rupees after adding 40% for future prospects and applying the appropriate multiplier of 16. The total loss of dependency is recalculated. The insurance company is directed to deposit the enhanced amount along with interest at the rate of 7% per annum from the date of the petition till the date of realization. The amount shall be deposited in the bank accounts of the claimants in equal shares within a period of 12 weeks. The award is modified. Accordingly, no order as to costs or stop.